There was recently a major U.S. Supreme Court case involving temporary protected status, or TPS, and it's now affecting hundreds of thousands of Haitians living in the United States. But there's also an enormous amount of confusion about what TPS is, what it does, and what the Supreme Court actually decided. Hi, I'm Nate Charles, and welcome back to the Rule of Law Brief. Now, before we get into the meat of it, I want to thank Steve Davies for suggesting this video. Steve and I are both kids from Lebanon County, Pennsylvania. We both went to Cedar Crest High School. I attended the U.S. Naval Academy, and just a few years later, he attended the U.S. Coast Guard Academy. Both of us ultimately retired as commanders, and given Steve's experience as a senior Coast Guard leader and the Coast Guard's vital immigration role within the U.S. Department of Homeland Security, I value his perspective on these issues. Thanks, Steve, for bringing this up. Now, some background on TPS. Congress created temporary protected status through the Immigration Act of 1990. The law now appears in Section 244 of the Immigration and Nationality Act. But the general principle behind temporary protected status is much older, and we'll get into that in just a minute. Distilled to its essence, temporary protected status allows the Secretary of Homeland Security to designate a country when its nationals cannot safely return because of armed conflict, environmental disaster, or some other form of extraordinary but temporary condition. TPS is not asylum. It's a different regulatory scheme entirely. It also doesn't come with a green card, and it is not a pathway to citizenship in the United States. As the name implies, it is also not intended to be permanent. It is temporary. But as the name also implies, it is a temporary protection for qualifying nationals of designated countries who are already present in the United States as of a certain cutoff date, specified in the administrative order. While TPS remains in effect, recipients generally cannot be removed to their designated country. And while they're here, they are also permitted to work legally in the United States. But again, this basic concept predates the 1990 statute, by decades, in fact. Beginning around 1960, the Eisenhower administration used a program called Extended Voluntary Departure to avoid returning people to countries experiencing war, revolution, or, again, natural disasters. But that program was not statutory in nature. It relied almost entirely upon the inherent authority of the President of the United States, which is questionable. In 1990, Congress created TPS as a statutory program. It also provided a more orderly statutory framework for how to grant TPS. TPS designations generally last between 6 and 18 months. The Secretary may extend it if dangerous conditions continue. That's why some supposedly temporary designations have lasted for years. The danger did not disappear simply because 18 months had passed. Haiti was first designated for TPS following its catastrophic 2010 earthquake. The designation was later extended and redesignated as Haiti experienced additional disasters, political collapse, gang violence, and severe humanitarian instability. However, the Trump administration recently determined that Haiti no longer qualified and moved to terminate its designation. Lower federal courts issued an injunction that temporarily blocked the termination of TPS while Haitians challenged whether the government had followed the statute and whether racial discrimination influenced its decision. That led to the Supreme Court's June 25th decision in Mullen v. Doe. In a 6-3 ruling, the Supreme Court held that the TPS statute generally prevents federal courts from reviewing the Secretary's decisions concerning the designation, extension, and termination of TPS. In effect, they held that the issue was not justiciable. It's just not the kind of thing you can bring to court. That ruling included challenges brought under the Administrative Procedures Act, claiming that the Secretary of Homeland Security failed to follow the required decision-making process. The Haitian plaintiffs also raised a constitutional equal protection claim. The court did not hold that every constitutional challenge is categorically unreviewable, but it did conclude that these Haitian plaintiffs, were unlikely, on the existing record, to prove that racial discrimination motivated Haiti's termination. The court therefore reversed the orders protecting Haitian and Syrian TPS holders while their cases proceeded. As a result, Haiti's TPS designation has been terminated. Approximately 350,000 Haitians have lost temporary protected status, and their employment authorizations have been revoked. Now, temporary protected status is overwhelmingly a good program. It promotes both the national security and the foreign policy of the United States. It gives the President of the United States the opportunity to, with one stroke of the pen, provide safe harbor for large classes of individuals who are affected by overseas conflict. From a foreign policy standpoint, temporary protected status is America at its best, and America showing its values to the rest of the world. Even in the most conservative circles, you'd be hard-pressed to find a group of serious pundits that generally question the value of temporary protected status. But the controversial nuance, and the nuance that was brought out by Mullen v. Doe, is the degree to which the courts have an opportunity to review the president's decisions. Believe it or not, under normal circumstances, I would actually be happy with the Supreme Court's decision in Mullen v. Doe. The President of the United States has access to better information than almost anybody else in the U.S. government when it comes to foreign policy decisions. His decisions are supposed to be rooted in the best information available from his diplomatic corps at the U.S. State Department and from the entire U.S. intelligence community. The problem with President Trump, of course, is that he's shown outward disdain for the intelligence process and has clearly based prior executive orders on racial issues. The quote-unquote Muslim ban from his first term is just one example. The problem with Mullen v. Doe is that it has directly held that the courts are not allowed to examine his decisions and stop him when he has acted arbitrarily or capriciously. In summary, the most problematic aspect of Mullen v. Doe is not the fate of a small group of Haitians or Syrians living in the United States, it's the Supreme Court yet again failing to put a check on executive power. Only time will tell how this decision will affect the credibility of the United States on the world stage.